reassuring myself that even if I had the day off, I was not going outside.
You're just not going outside. This is correct. Oh my goodness. So
Well, unlike you guys, I'm here. So,
well, I know you're downtown.
yes, I am.
I thought about coming to join you, but I didn't want to get in the car, go out like Shelly
I
said.
know. Smart move.
It is hot out
Let's
there.
see if we can move it along. I know we got a
Okay.
large
Got it.
calendar today, right?
It is. It is. And so, you know, Your Honor, the reset date is June the 27th.
Okay, so June 27th. Got it. All right, we'll get started. Ladies and gentlemen, good afternoon. We're going to begin our Fulton County State Court Expedited Accusations calendar. I see PD Armstrong. Are you by yourself?
Good afternoon, Judge. No, Ms. Wright is also representing my office today.
Oh, okay. All right. Hi, Ms. Wright.
Hello, Judge. How are you today?
Good. All right. So this calendar is for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and these cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to handle matters such as bond and possible arraignment or plea offer if one has been made by the state at this juncture. I think everyone heard the SAP reset date is June 27th. We're going to begin by reminding everyone that this whole entire proceeding is being recorded and live streamed on YouTube, so govern yourselves accordingly. I want to remind the defendants that you do have certain constitutional rights. The first being that you have a right to representation by counsel. You should know who your attorneys are by now. Also, you have the right to remain silent. Remember that anything that you state about the facts or circumstances or the occurrences of your case can and will be used against you. The state is here and they're listening, so listen to your attorneys. All right, who do we have first?
Position 2, Carter.
All right, this is 24 CR 003806Y, Shavandia Carter, charged with 1 count of battery, family violence, a 2nd count of reckless conduct, pretrial.
Second arrest, 2015 DUI, dismissed.
State?
Yes, Your Honor, if I may proceed.
Yes, I'm sorry, state.
Okay, thank you, Your Honor.
Yes.
This happened June 15th, 2024 at 3901 Campbellton Road Southwest. So this incident actually happened earlier this morning. Javon Griggs stated that his mother, and Javon Griggs is 16 years of age, stated that his mother started a verbal altercation with him when she could not find her marijuana. Mr. Griggs stated that his mother threw her TV at him and broke several items in the room. The defendant had a gun in her hand, and he held her because he was afraid she would use it against him. He stated when he was trying to take the gun away, she hit him in the forehead with the gun, and he got the gun away from her and gave it to a neighbor, Vincent Wansley. The officers did observe a knot to Mr. Griggs' forehead, which was corroborating the injury that he told them he suffered from being hit in the head with the gun. The defendant did claim she hit her son while he was choking and holding her, but officers were able to determine she was the predominant aggressor based upon his injuries and the corroborating damage to the television, which matched his version of events and not hers. She also had no injuries to her persons that the officers could see. I will state that we had an opportunity to speak with the neighbor, Vincent Wansley, who he turned the gun over to. He stated that the victim did give him his mother's gun. He stated he has witnessed past incidents, and he's not sure who the problem is, the son or the mother. And he stated that he believes Mr. Griggs is now staying at the grandmother's house because DFACS has gotten involved. We are asking for a $7,500 surety bond, $2,500 on the family violence battery, $5,000 on the reckless conduct. No further contact with Javon Griggs unless it's per a DFACS recommendation. No alcohol, drugs, or weapons. Alcohol, ADET, and comply with any DFACS recommendations. That's all for the state. We would like to sound for Javon Griggs in case he is here, although he is a minor.
Okay, Javon Greg, is it Griggs or Greg?
It's Javon Griggs.
Okay. Javon Griggs. All right. Go ahead, PD Armstrong.
Thank you, Judge. We're asking for a signature bond through the jail in this matter. Unfortunately, there is an open juvenile case involving the defendant where she is the alleged victim in that matter, and her son is the alleged assailant. Again, that is a juvenile case, and the next court date is in July, which is my understanding. It's July. I apologize. Either way, we would ask that if there is a no contact provision ordered in this matter, that it would be through DFACS or for the purposes of facilitating any legal proceedings in juvenile court. The apartment that this alleged incident took place in, the rent is paid by Ms. Carter. She is employed, and she has actually also reached out to DFACS asking that that there be some plan put in place where her son no longer lives with her because she is in fear for her life. So again, we are asking for a signature bond through the jail.
And Your Honor, the state didn't ask for a stay away. We're just asking for no further contact unless it's per DFACS order.
And so the victim is now staying with the grandmother.
That's what the neighbor believes, but we have not been able to get in touch with the victim because he is 16.
Right. And I'm wanting to make sure that at this point the victim is safe, or that they're not going to be together for a moment to cool down. Open juvie case. So I am concerned about safety here. And PD Armstrong, does Miss Carter work or anything?
Yes, Judge, she's gainfully employed. She pays the rent, and it is not a low amount, and she doesn't receive any financial assistance for that.
Are there other children in the home?
To the best of my knowledge, there are not.
Oh. All right. Since I guess the only history was this 2015 case that was dismissed, so I'm almost treating her as if she doesn't have it as a first arrest, but I'm very concerned about the allegations. Obviously, the handgun bothers me. And the neighbor has the gun. Do we need to have that gun turned over to the sheriff's department, or?
Yes, Your Honor, we would ask that any firearms in the home be turned over to the sheriff's office. I will also point out that although the victim is 16, he just turned 16 3 months ago.
No, he's a new 16, not getting ready to turn 17.
That is correct.
Okay. I'm going to order a signature bond through the jail, but I'm going to make it the $7,500 signature bond through the jail, $2,500 on the battery, $5,000 on the reckless. I'm going to order that there be no guns, weapons, alcohol, or drugs while on bond. Any guns are to be turned over immediately. Any guns in the home be turned over immediately to the sheriff's department. And I won't order an ADT at this time, not for sure. I guess if she can afford it. I don't know if I heard about alcohol. Of course, I heard about marijuana or maybe drugs. So I will wait till we get further into the case to determine that. But I'm going to order no further contact with the victim, Javon Griggs. Follow any DFACS counseling or plans. But I'm ordering no further contact. I'm assuming DFACS is going to do the same. I want to make sure I don't have anything contradictory. And I think that Deputy Falk said it to follow the DFACS plan, but if they are trying to unify them and do that and allow any supervised visitation or anything like that, she can do it through DFACS to be supervised. But hopefully they will honor the stay away right now unless our bond gets modified. And that's all I order at this time.
And Your Honor, the state would just object to a signature bond through the jail. just because number one, this did involve a firearm and did involve her essentially pistol whipping her 16-year-old son.
Well, if I make it through pretrial, you can be monitored and maybe at least get some type of possible anger management course through pretrial.
So I need some whiteout,
Yes. Yes.
same amount.
Same amount, 7,500, same amount. Let's do it through pretrial. And have her to take a 2-day anger awareness course,
What's your level?
be level 1.
All right.
You got that, Miss Holly?
I have it, Your Honor.
Thank you.
Position number 9, Ms. Harrington.
All right.
Was that
24
position
CR.
9, Your Honor?
Yes,
Oh,
number
9 is Harrington.
Yeah, 9, I have Harrington. That's why I was
Me
trying
too.
to make sure we had the right person.
Yeah, this is Harrington, right?
Okay.
Uh-huh.
Yeah.
I think she said a different name.
I did not hear Harrington.
Oh,
No. Deputy, who do you have?
I'm from the South. I did say Harrington.
Oh,
Uh-oh,
got
you're
it.
from the
I
I'm
thought she
gonna
said
blame
it.
that on pretrial.
I heard Harrington.
Okay. Sorry about that, Deputy. 24 CR 003814A, Barbara Harrington. 1 count of simple battery, family violence, pretrial.
First arrest.
State.
Yes, Your Honor. This incident happened June 13th, 2024 at 340 Farm Track Road in Roswell. The defendant stated she slapped her 18-year-old son, Paul Harrington, after a verbal argument. She was lecturing him and he stated, "If you hit me, I'm going to hit you back." She did admit to police that she slapped him because she wanted to push his limits and see if he'd slap her back, which he did, and then left the scene. Michael Harrington, who's a witness, gave the exact same story of the events, and the juvenile AH also witnessed the incident. As you heard, there is no prior history. We did speak to Michael Harrington, who stated that they all reside at that location, and that Mr. Paul Harrington had just graduated from high school and turned 18. He stated that the Mr. Harrington feels he can come and go as he pleases and was being defiant and disrespectful, which is why this incident happened. And he stated his son left the home after this incident and he hasn't heard from him. Michael Harrington is the father of Paul Harrington and the wife of the defendant. He stated he would like a no further violent contact, although he is not the victim, so that is not really up to him. I will say we are agreeable to an SOB through the jail, given the fact this is her first incident. We are also agreeable to no further violent contact with Paul Harrington, no alcohol, drugs, or weapons, and we would like her to take a 1-day anger awareness course. That's all for the state. And we would like to sound for Mr. Paul Harrington in case he is here.
I think I see Mr. Harrington.
That
I
may
see.
be Michael Harrington, the
I'm
father.
sorry, that is the father. Okay. So is Paul Harrington with you, Mr. Michael Harrington? Maybe not. I don't see him.
I'm here.
Oh.
He's not with me. I'm sorry.
Okay, he's not. Okay. Since you're not the victim in the case, Mr. Harrington, I will hear from your wife's attorney, and don't really have anything that I would need to hear from you at this point. If I do, I'll ask you. I think I have a good grasp of the facts, okay?
Yes, ma'am.
All right, thank you. All right, go ahead, PD Armstrong.
Thank you, Judge. We would be amenable to the state's the bond that the state has presented at SOB jail with those conditions. Thank you.
All right. I'm going to order a $3,500 signature bond through the jail. I'm going to order, as the state has recommended, no further violent contact with the victim, Paul Harrington. Or is it Paul Harrington?
It is Paul Harrington, Your Honor.
His last name is Harrington. All right. But I will say, Mr. Harrington and the defendant, Barbara Harrington, to be careful. My inclination is to say no further contact since he's gone from the home, staying out to make sure. I know it's been a couple of days, but that there's been the ample cooling down. I'm assuming that your son has somewhere to go stay since he's been there a couple of days. But the state has recommended no further violent contact, which means he can come back. So if you're okay with that, Mr. Harrington, I guess for the safety of everyone in the home, there's another juvenile there. So I'll go ahead and order no further violent contact. I'm going to hope that you all have the means for Miss Harrington to take a one-day anger awareness course.
Yes, ma'am.
Okay. All right. No guns, no drugs, no alcohol, no weapons while on bond. And that'll be it.
Position
All right.
14.
This is 24 CR 0038170. Julian Giuliano, charged with one count of false report of a crime.
First.
First, okay. State.
Yes, Your Honor. The defendant is accused of falsely reporting that she was sexually assaulted at a Ross store located in Alpharetta. The defendant stated that she reported the assault because she wanted to make her boyfriend feel sorry for her. The state is recommending a signature bond through pretrial services, no drugs, weapons, or alcohol while out on bond.
Your Honor, no
Alright.
objection here to that. And I believe she's 19, so I think her dad has to sign her out.
Now pretrial, she's over 18. I think it's 18 and under. I think 19. She just made it unless she turned 19 yesterday.
I mean, it's really like 21 and under, but we,
Oh, 21.
we
That was my
throughout
understanding.
the history of this court, we have always, if they was 19 or older, the judge not giving them no cosigner. But I mean, if you want to have one, that's fine.
Is she independent or she's still living at home?
She lives at home with her father. And she does have a job. She does go to school. So it would be entirely up to Your Honor.
Oh, well, you did. Well, if she's still in school, I was thinking maybe she graduated. So she's still in school.
She's in college, Your Honor.
Oh, college. Okay, not high school.
No.
Okay. Okay. Well, I won't require a cosigner. We should be able to keep up with her. She should be returning to court. So I will not require a cosigner. But I will order a $3,500 signature bond through the jail. And no drugs, no alcohol, no weapons, no guns while on bond. And I thought about, well, I guess there's nothing else the state was asking for in regards to the boyfriend or whomever with this false report. I mean, do we order her to stay away from him?
He
For
was
his
not
safety?
involved, Your Honor. He was not involved at
Okay.
all. He was not accused at all. This was a side situation.
Okay. Any other comment from the state?
No, Your Honor.
Okay. All right. Well, that'll be it.
What's that amount?
3,500.
Position 18. Ms. Powell.
This is 24 CR 003821Y. Natasha Powell, charged with one count of battery, second count of criminal trespass. Pretrial.
First.
All right. State ASG, is it Mukake?
Mokake, yes, that is correct.
Okay, I was probably closer than some people. I apologize.
No worries.
All right, go ahead.
The defendant is accused of entering the victim Camille Jones's home without authority. She's also accused of punching the victim several times and also biting the victim on the leg. The defendant also entered the victim's living room and threw items that were in the victim's living room around. The victim sustained a large bite mark on her leg, and she was also bleeding as a result of the attack. Our office has had a chance to speak with the victim, Ms. Camille Jones, who confirmed the events in the warrant and stated that before this incident occurred, the defendant had threatened her. The victim stated that she is afraid of the defendant, and the defendant did destroy many of her belongings, and that she would like no further contact as well as restitution. And she says that she's not in need of a stay away because she's in the process of moving, but because she hasn't moved yet, the state will still be recommending a stay away. So the state's recommendation is a $2,500 surety bond for the battery and a $500 surety bond for the criminal trespass. No further contact with the victim, Camille Jones. Stay away from the incident location. No drugs, weapons, or alcohol while out on bond, and 2-day anger awareness. And at this time, I would ask the court to sound for the victim, Ms. Camille Jones.
All right, Ms. Camille Jones. Camille Jones. Nope. All right, go ahead, PD Wright.
Yes, Your Honor. Miss Powell is 48 years old. She holds a master's degree. She came to Georgia to go to college. She has been here for 30 years. As you heard, she does not have a criminal history. The complaining witness is someone that her husband was having an indiscretion with. Miss Jones continuously sent letters to her home. And there is no reason for the court to think that Miss Powell would skip out and not show up to court. She has been a responsible citizen her whole entire life. I would ask that this court consider a signature bond. Ms. Powell has no issue with a stay away, with a no further contact, and any other conditions that the court would ask of her.
All right. I will order a $3,000 signature bond through the jail. That'll be $2,500 on the battery and $500 on the criminal trespass. Gonna order a stay away from the incident location, which I believe is the home of the victim. No further contact with the victim, Camille Jones. And that means no further contact at all. Stay 200 yards away from her, Ms. Powell. I'm going to also order no drugs, alcohol, weapons, or guns while on bond, and that's all I'll order at this time.
Thank you, Your Honor.
Mhm.
Position number 19, Ms. Prince.
Okay.
Hello?
24 CR 003823C. Altiania Prince, charge of 1 count of criminal trespass and damage to property. Pre-trial.
Second arrest. I got a 2012 ag assault with no disposition.
Okay. State.
Yes.
ASP.
The defendant is accused of damaging the apartment door belonging to Brandy Hunter by kicking it and hitting it with her cell phone. The defendant's cell phone did have the same paint color as the door on it. Our office has had a chance to speak with the victim, Miss Brandy Hunter, who stated that her and the defendant have been in a relationship for about 4 years, and they do reside together at the incident location. Both of their names are on the lease. She stated they do not have a domestic violence history, and she is not afraid of the defendant. She has confirmed the events in the warrant and stated that she believes the defendant was just intoxicated and the defendant is not a violent person, and she wants to continue contact, and she also wants the defendant to return to the residence. In light of this, the state is recommending a signature bond through pretrial services, no drugs, weapons, or alcohol while out on bond.
All right. PD Wright?
Yes, Your Honor, we do not object to that. Thank you.
Okay. I will order a $2,500 signature bond through pretrial, level 1. I'm gonna order a 2-day anger awareness course through pretrial. I'm going to order no drugs, alcohol, weapons, or guns while on bond. Going to order no further violent contact with the victim. And I guess since the victim is requesting, we won't do the stay away then. We'll see how they do. I hope it's calmed down. It's barely been 24 hours, so I hope that it's over if I allow Miss Prince to go back to the home.
Thank you, Your Honor.
Number 20, Ms. Reed.
Twenty-four CR 03824Y, Alexis Reed, charged with 1 count of battery family violence.
First arrest.
State?
Yes, Your Honor. This incident occurred January 14th, 2024. The victim in this case, Joanne Messina, and the defendant were in a relationship and were living together at the time of the incident. The defendant had locked herself in the victim's room, and the victim was trying to regain entry. Upon entering into the bedroom, the defendant snatched the victim's AirPod from her ear. The victim took the AirPod back and was changing her clothes when the defendant snatched the victim's shirt and began hitting her. The defendant shoved the victim's face into the wall, which caused the victim to fall onto the bed. The defendant then got on top of the victim and began pushing her head into the mattress. The victim sustained bruises as a result of the attack. Our office has had a chance to speak with the victim, Ms. Joanne Messina. The victim stated that her and the defendant have known each other for years and had been dating for 6 months. They both reside at the incident location. They do not have a domestic violence history, and she is not afraid of the defendant. The victim stated that she wants to continue contact and for the defendant to return to the residence. The state is recommending a $2,500 surety bond, no further violent contact with the victim, no drugs, weapons, or alcohol while out on bond, and 1-day anger awareness.
All right, PD Wright?
Yes, Your Honor. Ms. Reed is 23 years old. She has lived in Georgia for the past 6 years. She does have a job. She's fully employed. We ask, because she doesn't have a criminal history, because the complaining witness doesn't fear for her safety and wants her to return, we'd ask for a signature bond on this case, Your Honor.
And I do see that the victim in this case, Ms. Joan Messina, is on the Zoom, so I would ask the court to sound for her.
All right, Ms. Joan Messina,
Yes, ma'am.
do you wish to briefly address the court today?
Yes, ma'am.
Raise your right hand for me. You affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. Are you in fear of Ms. Reed?
No, ma'am.
Do you want to have further contact with Ms. Reed?
Yes, ma'am.
Okay. All right. Any cross-examination questions by either side, either counsel?
No, Your Honor.
Okay. All right. I will order that $2,500 signature bond through the jail. I'm going to order no drugs, no alcohol, no weapons, no guns while on bond. I'm going to order no further violent contact with the victim, Miss Joan Messina. And I guess that'll be it.
Thank you, Your Honor.
Thank you.
You're welcome.
Number 8,
This is 24 CR 003813E. Armani Hammonds charged with one count of battery, second count battery against a female who's pregnant, third count of simple battery, and a fourth count of simple battery against a person who's pregnant. Pre-trial.
This is first. He's 17, so he would need a cosign if needed.
Okay. State.
Yes, Your Honor. This incident happened June 11th, 2024 at 2000 Cannon Court. Alexis Griffin stated she had had an altercation with the defendant, who was the son of Brittany Hammonds, who she had had a physical altercation with earlier that evening. While she was standing in front of the apartments, the defendant walked up, slammed her onto the ground, and began fighting her. The defendant stated that she was 2.5 months pregnant. Oh, sorry, Miss Griffin stated she was 2.5 months pregnant at the time of this incident. And later that evening, Rihanna and Brandon Hammonds, then who are related to all of these individuals, then jumped on Serenity Griffin, who received a black eye and a fractured jaw. So there are, I believe, other charges unassociated with this defendant, but it appears there's just an ongoing back and forth between all the parties. We did attempt to contact the victim. The number we had was disconnected. We are asking for a $5,000 surety bond. That's going to be $1,500 on the battery and per battery charge, and $1,000 per simple battery charge, for a total of $5,000. No further contact with Alexis Griffin. Stay away from 2000 Cannon Court. No alcohol, drugs, or weapons. We're also going to ask for 2-day anger awareness in this case. And we would like to sound for Miss Alexis Griffin, and that's all for the state. I do see Miss Brittany Hammonds, who was also involved in all of this here in court, but we are looking for Miss Alexis Griffin, who is the victim in our case.
Can I say something?
No, ma'am. No, ma'am.
Okay.
Yeah, you're not the victim in this case, but I hope that this back and forth and these incidents are ready to stop. I'm here to protect the victim, and I understand, I guess she's still pregnant, and this has got to stop. I'm just going to say that because there are going to be more people down here in Fulton County Jail. Are you going to co-sign for your son, Miss Hammonds?
Yes, ma'am.
Okay. That's about all I need to ask you at this point, and hopefully instruct him to not have allegations of putting hands on women, especially pregnant women. So not impressed by the allegations at all, especially a young man at 17. To learn a little bit more respect in his life and how to handle situations. I understand. Excuse me.
I was just going to say that I represent him.
Oh, thank you. I didn't see you, Miss McLeod. I apologize.
It's
go
okay.
ahead, Miss McLeod. Thank you.
I just wanted to say, Your Honor, there is a lot more to this story than is heard on the surface. My client is 17 years old. He's in high school. He's in the 11th grade. He's never been arrested. My understanding is that his mother, Miss Hammonds, was being attacked, and had been physically attacked, and I do believe the warrant also says that, by the alleged victim. My client merely intervened to protect his mom. So his mom was initially the victim, and my client was just trying to protect his mom. Nothing more, nothing less than that. This is what happened. So the allegation that, my client was beating up some pregnant woman, first of all, nobody knows that this woman was pregnant. And second of all, he was just intervening to protect his mother, who had been physically attacked by the alleged victim. I just wish to put that on the record. We are okay with the signature bond. This is what I will be asking for my client. He has absolutely no record. He is a high school student in the 11th grade, and his mom is here to co-sign for him. I've already spoken with her. Nothing further, Your Honor.
All right. I'm going to order that $5,000 signature bond. I'm going to order it through pretrial. What is he, level 1 or 2?
He's in high school, Your Honor, so
Level
I would ask
1.
the court to take that into consideration.
All right, it'll be a level 1. But I want him to take a 2-day anger awareness course through pretrial. And so, and that breakdown was the same, Ms. Bridgewater, 1,500 on the battery counts 1 and 2, and 1,000 on counts 3 and 4. So that should total 5,000. And I want him to have no further contact with Alexis Griffin and to stay away from 2,000 Cannon Court. Who resides there? The victim?
Yes, Your Honor. And I would like to point out that even the warrant says the officers went out there the first time because of a fight with Miss Hammonds, and then came out a second time when they were called out because the defendant jumped on Alexis Griffin. So this isn't just a mom's protecting in the middle of a fight. He's jumping in as a third party. There was a break in the fights between the first fight that they were called out to and the second fight they were called out to.
All right. Well, I hope everybody's finished fighting now. So that's going to be the order of the court. 5,000 SOB pretrial level 1. No drugs, alcohol, guns, or weapons while on bond, Mr. Hammonds. And let me do this. One other thing. He is ordered to go to school starting in August. Make sure he's in class. If not, needs to be enrolled in a GED course. And just like I would do on any other quote unquote minor, I put a curfew on him. And that curfew is going to be from, does he work, Mom, or Miss McLeod?
He do landscaping.
I'm sorry?
Landscaping. He do landscaping.
Oh, well, he wouldn't be doing that at 10
Landscaping.
o'clock at night. He can't see.
Right.
Okay, so 10 p.m. to 7 a.m. So he needs to be in the house, 10 p.m. to 7 a.m. Okay? All right. Thank you all.
Thank you, Your Honor.
Mhm.
Next.
22,
Yes.
this is 24 CR 003827A. I have Mr. Rodney Wilkinson. Charge of one, do we want this last or we want to take it now? It's SB. I didn't see that.
Your Honor, I'm okay with us going forward with it.
Was it a courtroom full of people, full of defendants? Generally, we told for the safety of them, but I don't know. I can at least stop the live stream, but we will record. But I usually take these last when the courtroom is clear. Deputies, and I guess if his attorney, Ms. McLeod, doesn't have an issue. I don't know what the facts are, but
Well, it's a first arrest. That's what I have.
at least we know that. If you want to still go forward, Ms. McLeod?
Your Honor.
I
We're
just
fine
need-
with that.
Your Honor, I think it may help. If with Miss McLeod's permission, I can put in the chat to you and Miss McLeod basically the basic facts of this.
Okay.
I have some idea as well, but go ahead and
Right.
put it.
Yeah.
Yeah.
Oh, I see. Okay. All right.
Right.
That's a little different from some of the others we've had. Okay.
Correct.
Just want to make sure. Gotcha. Okay. All right. I'm comfortable with going forward then. I was thinking something a lot different. Go ahead, Deputy or who? I'm sorry. ASG.
So Deputy Falk is going to put the facts in the chat, so I won't go into detail.
Okay.
But
Miss Makake, you can still go into detail. I was just letting them know it was fine for us to proceed. We did not need to hold it till last.
Okay. So the defendant is accused of sexually assaulting his coworker, Miss April Winston, after the victim, Miss Winston, told the defendant she would not be going to have a drink with him. The defendant continued to follow her to her car. The defendant attempted to hug the victim from behind. And as she was turning around, he did grab her butt and also kiss her on the cheek. The defendant then told the victim to come live with him and that he would take care of her. This is not the first time the defendant had been inappropriate with the victim, and she had previously reported him to their jobs HR department. The state's recommendation is a $2,500 surety bond for the sexual battery and a $2,500 surety bond for the simple assault. No further contact with the victim, Ms. April Winston. No drugs, weapons, or alcohol while out on bond. And at this time, I would ask the court to sound for the victim, Ms. April Winston.
All right, is Miss Winston here? I don't think I see anyone with that name. All right, go ahead, Attorney.
Well, my client is 57 years old. As Richard has stated, he's never been arrested in his life. He's gainfully employed. In fact, both of these people work for the same company. This incident allegedly happened in January of 2023. This is well over a year ago. It's been investigated by HR and determined that my client did nothing wrong. This is a situation where two co-workers were out together, and one was confiding in the other, and my client was just trying to comfort this person when she was talking to him about some work-related matters. It wasn't a situation of a sexual assault or not. He was surprised that she chose to turn this into that sort of thing, and we suspect it might just be a situation of a money grab or somebody trying to see whether they can file some kind of complaint with HR. But it's been well over a year, as we said. HR has determined that nothing inappropriate happened, and they both continue to work at the same place, not at the same location, but they're still employed for the same company. I would ask for a signature bond through the jail for my client. And he's happy with no further contact with this person. They do not work in the same facility. Nothing further, Your Honor.
Our office has not had a chance to speak with the victim to confirm that nothing happened from the HR matter that she did file. At the time of the incident, and it states so in the warrant, the victim stated that she had filed a complaint with HR, but she wasn't sure where it was in the process.
Well, it's been well over a year and a half. My client still works there, and I believe him since he's asserted that HR did their own investigation. He's still employed there a year and a half later. So
yeah,
it would tend to support his position that, nothing happened, that they determined there was no wrongdoing.
Well, I won't say anything didn't happen, but I would think after a year and a half, unless this is some company with trillions of employees, that HR would have taken some action. So I'm just surprised that it's, that long ago. I thought it was recent.
January of 2023.
Okay. All right. I'm going to order that $5,000 signature bond through the jail, $2,500 on each charge. No drugs, alcohol, weapons, or guns while on bond. I'm going to order no further contact with the victim, April Winston. And he is not to come around her or have any contact with her, and not to be within 200 yards of her. What I am concerned is, if there's some general meeting with all the employees or a company picnic or things of that nature, he's going to have to refrain while on bond to make sure that he does not violate the conditions and is not more than 200 yards close to her, or stays 200 yards away from her. But
based on what I am told, Your Honor, they do not work in the same physical facilities, fortunately.
Right. Well, that's good. All right. Just make sure that you have no further contact with Miss April Winston, Mr. Wilkinson. All right. That'll be it.
Thank you, Your Honor. And that concludes my business before the court today. May I be excused?
You may go enjoy the hot sun. Yes.
Thank you, Your Honor.
All right.
Position 4.
This is 24 CR 00 3809C, Ricky Crane, charged with 1 count of criminal trespass. Pretrial.
21, 2023 trespass, possession of drug-related objects, conviction. Another 2023 arrest for trespass conviction. 2012 trespass conviction. Jail was the wreck.
All right. Deputy Falk.
Yes, Your Honor. This incident happened June 14th, 2024 at 1030 White Oak Avenue Southwest. Peter Utomwin, who is the owner of the property, reported a criminal trespass. The defendant was served with a criminal trespass warning on May 29th of 2024, so about 2 weeks before. On June 14th, Mr. Utomwin saw the defendant standing in the front yard. The defendant advised he lives at that property, but the officers were able to verify that he does not live there, and they were able to verify the previous criminal trespass warning that had been given to him back in May of 2024. The defendant has, as you've heard, 21 cycles. However, most of them are for criminal trespass. We are agreeable to signature bond through pretrial services. Stay away from 1030 White Oak Avenue Southwest. No further contact with Peter Utomwin, which is Utomwen. We would like to sound for him at this time, and that's all for the state.
All right. Edie Armstrong.
No objection to SOB pretrial. Thank you.
All right, and we don't have a victim on, I don't believe. I've seen anyone with that name.
And we were unable to successfully make contact with him, so we did not receive a contact back.
All right. I will order a $3,000 signature bond. I'm going to, and one quick question, PD Armstrong, is Mr. Crane working?
No, Judge.
No.
No.
That concerns me with all of the history with trespassing. I don't know if he's trying to find places to live or just what we have going on. Hope is ready to stop.
He reports that he can live with his mother, and I've advised him that would be a good idea at this time.
With this 3,000 SOB jail, I'll go ahead and do it through the jail. No further contact with the victim, whose last name I cannot pronounce, Utomwe. No further contact with him in any manner, Mr. Crane, and to stay away from that 1030 White Oak. No drugs, alcohol, weapons, or guns while on bond. Okay. That should be it.
Number 6.
This is 24 CR 003811F. Kenneth, is it Ferrara? Charge of 1 count of simple assault, the 2nd count of disorderly conduct. Pre-trial.
Second arrest, 2001 shoplifting was the last, and jail was the wreck.
All right. PD Falk.
Yes, Your Honor. On June 14th, 2024, at the intersection of Behaney Road and Mayfield Road in Alpharetta, the defendant cut off Dawn Clements, Clements, with his vehicle on the roadway and stopped in the roadway to prevent her from moving her vehicle. The defendant then exited the vehicle and approached Ms. Clemens' driver's side window while yelling at her and punched the driver's side window twice, which placed her in fear for her safety. We would like to note that we could not make contact with Ms. Clements due to not having the police report or any of her biographical data, which would have allowed us to make contact with her. But unfortunately, due to the time constraints, we were not able to obtain that. We are asking for an SOB through pretrial services, 2 days of anger awareness, no further contact with Dawn Clements, and no alcohol, drugs, or weapons. The state's asking for pretrial services instead of the jail because we are concerned about the nature of this offense. It appears to be somewhat of a road rage incident, but it put this woman in fear of her safety that this defendant just got out of his car, blocked her so she could not leave the scene, and then punched the driver's side window multiple times.
All right, Edie Armstrong.
If Your Honor would be inclined to SOV jail, we would of course ask for that, but we don't object to the pretrial.
Okay. All right, I'm going to order a $5,000 signature bond through pretrial. That'll be 2,500 on, I'm sorry, 3,000 on the disorderly and 2,000 on the simple assault. So it's a total of 5. I'm going to order that through pretrial, level 1, 2-day anger awareness course. Stay away. Well, there's no stay away location, but no further contact with Dawn Clements. Be 200 yards away from her. Have no contact with her whatsoever. And I think that's it. To leave out anything, counsel?
No
Your
alcohol,
Honor, you
drugs, or
said
weapons.
3,000 on the disorderly?
Yes, and 2,000 on the simple assault.
Okay, thank you.
Mhm.
And just the standard no alcohol, drugs, or weapons
Oh,
provision, Your
that's
Honor?
right. Yep, no drugs, alcohol, weapons, or guns while on bond.
Thank you, Your Honor.
Give me 1 second. Hold for a minute. All right. So do we have next?
Position number 5, Dudley.
Okay.
Judge, I don't mean to speak out of order. I do apologize, but I have yet to speak with Mr. Dudley. I apologize to the court and to the jail. I'm not sure if it would be possible to be put in a breakout room with him, or I could call the courtroom.
Okay. Which way would you like to do that, Deputy?
We can call her. Do you want him to call you now or you want to wait?
I'll leave that to the court.
Oh, I guess it depends on who you call next if it's not your case.
Yep.
I'll call her now. We're going to do position number 13, Jones.
Oh. This is 24 CR 003826E. Jaquavius Jones, charged with 1 count of disorderly conduct and a 2nd count of willful obstruction. Pre-trial.
17. Got an open driving and drug charge out of Superior Court 23 CP 218424. On probation, 2 counts of armed robbery, ag assault with intent to rob, hijacking a motor vehicle, possession of a firearm during the commission, possession of a firearm by convicted felon. That's 19 SC 172723. 2023 was the last arrest, probation. 2017 and 19 probation. That's it.
All right, State.
Yes, Your Honor. Officers approached a group of men, which included the defendant, who were gathered on the sidewalk and were obstructing the flow of traffic. The defendant began talking about exercising his rights and then told one of the officers that he'd be dead. The officer told the defendant to put his hands behind his back, and the defendant placed his forehead to the officer's head and said that he wasn't going to jail. When officers tried to handcuff the defendant, he held onto a property fence that was nearby and refused to place his hands behind his back. The state's recommendation is a $1,500 surety bond for the disorderly conduct, where the defendant told one of the officers that the officer would be dead, a $1,000 surety bond for the willful obstruction of law enforcement, no drugs, weapons, or alcohol while out on bond, and a stay away from the incident location.
All right. PD Wright?
Yes, Your Honor. Mr. Jones is 34 years old. He does live in Atlanta. He's lived in Atlanta his entire life. He does have a job. He works for a drilling company. He did get his GED. We are asking, he is stable. He is living with his girlfriend. We're asking for a signature bond, Your Honor, on this case. My understanding is that Mr. Jones and his friends were standing on a sidewalk. And I'm not really, the warrant doesn't really talk about what kind of traffic it was that these gentlemen were impeding. They were just standing there, and then they were approached by police. They were not causing any kind of havoc or anything like that. Again, I'd ask for a signature bond for him.
All right, I'm going to order the $2,500 surety bond, $1,500 on the disorderly, $1,000 on the willful obstruction. With that surety bond, going to order a stay away from the incident location. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I guess that's it. Did I leave anything else out, counsel?
No, Your Honor.
Okay.
Position number 15.
$24 CR 003818A, David Nimi. Charge of 1 count of theft by shoplifting.
38. He had a felony shoplifting charge as well. 2024 probation, got an open robbery obstruction, 23 CP 218410. Got a 2023 battery conviction, 2022 probation FTA, and some more probation violations.
All right. State?
Yes, Your Honor. The defendant is accused of stealing food and beverage items from the Chevron gas station located at 1739 MLK Junior Drive in Atlanta. I would like to bring it to the court's attention that the defendant does have a 2016 theft by shoplifting arrest, a 2023 theft by shoplifting arrest, as well as theft by receiving convictions from 2006, 2001, and 1998. The state is recommending a signature bond through pretrial services. Stay away from that incident location, which is the Chevron located at 1739 MLK Junior Drive Northwest. No drugs, weapons, or alcohol. And because of his history, we are also recommending that he take an anti-theft course.
And he got a $4,000 good bond and felony earlier for 1 misdemeanor shoplifting, 1 felony.
All right. I'm going to order a $2,500 surety bond.
Judge, I don't think defense won.
Huh?
I don't think
I'm
defense
sorry.
won.
I'm sorry. Please forgive me, PD Wright.
I understand, Your Honor. Your Honor, Mr. Noom was caught shoplifting food because he's hungry. He and I spoke. He desperately wants help trying to get on his medication. I sometimes get cases like this, and what I try to do is contact the Superior Court defense attorney and ask that we work, because those bonds are usually higher. We try and work together to see if we can get the client on a program like PAD that can help him get on medication, get housing, all the things that someone like him would need. Because he already has a felony bond, I'd ask that this be a signature bond to not keep putting barriers on his ability to be part of a program like PAD. And I'm sure Your Honor is aware, they take in clients usually with 10 days worth of medication and try and get them stable and situated. All of these crimes are crimes of chronic homelessness and lack of access to mental health resources. And I'd ask that Your Honor agree with the state's signature bond considerations.
Well, I guess he's not going anywhere, but I just looked at the number of cycles and I do understand.
And this is not he's not a violent offender. I think that we really just need to get him on a program. And if we can do a signature here and then try and work something out with Superior Court so that you know, we can try and get him stabilized.
All right, I will grant that $2,500 signature bond. And I guess it would be through the jail. And then hopefully you all can work and get him some resources.
Sure will. Thank you, Your Honor.
No drugs, alcohol, weapons, or guns while on bond. I will say to stay away from that Chevron on MLK, which is the incident location.
Yes, Your Honor.
Okay.
Position number 17.
'24 CR 003820B. Robert Payne, charged with 1 count of simple assault, family violence. Pre-trial.
Fifth arrest, 2021 probation. They got he's on probation out of car for armed robbery, 3 counts, and 4 counts of ag assault. I'm not sure when it ends, though. I have to check.
All right. State.
The defendant and the victim, Miss Renisha Dean, were having a verbal dispute when the defendant grabbed the victim by her shirt while he was yelling in her face. The state is recommending a $1,500 surety bond for the simple assault. No further contact with the victim, Miss Renisha Dean. Stay away from the incident location. No drugs, weapons, or alcohol while out on bond. And I would ask the court to sound for the victim, Miss Renisha Dean.
Miss Renisha Dean. I don't think I see anyone with that name online. All right. Go ahead, PD Wright.
Yes, Your Honor. Mr. Payne does have a 2-year-old child with the complaining witness. I did speak to him about legitimizing his child so that he can have contact and rights and be able to provide for his child. He is of very limited funds. I did explain to him that he cannot go back. He'll likely not be able to go back to that location. I could not get a hold of the complaining witness either to get her on here or at least talk to her. So I'm not really sure what her position is. I would ask for a signature bond. And that's all, Your Honor.
Okay. I will, well, he has the probation, open cases. I will order the $1,500 surety bond. Is he working too, or did you say that?
He's not currently working, Your Honor.
I'm going to order a $1,500 surety bond. I'm going to order no further contact with the victim, Benicia Dean. Going to order stay away from her location, which I believe was an incident location. No further contact, no drugs, alcohol, weapons, or guns while on bond. And I guess that's it.
Thank you, Your Honor.
Mm-hmm.
We're gonna go back to position number 5.
Right. This is 24 CR 003810F to Corey Dudley. One count of criminal trespass and damage of property, and second count of disorderly conduct. Retrial.
What we got here? 8 total. He went to felony earlier, got a $12,500 split bond. Let's see. Got an open case in state court, possession of marijuana, fair evasion. Got an open obstruction out of state court. Open armed robbery, ag assault, a deadly weapon out of Superior Court. 23 SC 19039-3. And the FTA from 2023 and 2022.
Okay. State Deputy Falk.
Yes, Your Honor. This happened May 29th, 2024 at 2040 Stanton Road, apartment F12 in East Point. Ashanti Barber, and that is ASHUNTI, was speaking with the defendant, her boyfriend, when the communication turned violent. Miss Barber ran to her mother, Tracy Thompson's house so she wouldn't be attacked. The defendant entered the residence. Miss Barber entered the residence and closed and locked the door so the defendant could not enter. The defendant began kicking the front door until the door frame was damaged and the door opened. And at that point, the defendant fled the scene. We show, again, as you've already heard, a 2022 FTA from Cobb, a 2023 FTA from Fulton, a 2022 possession of marijuana and fair evasion, that's 22 CR 000274. The defendant made a $1,400 surety bond on that case after his arrest for failure to appear in December of 2023. Then he has a open 24 CR 003810F, obstruction of a law enforcement officer, where he was given a $2,500 surety bond in December of 2023. The defendant also has a 23 SC 190393 armed robbery aggravated assault case that is also open with a $75,000 surety bond, and a 24 PI 004253 possession of marijuana and possession of marijuana of MDMA with an incident date of June 12th of 2024. And the possession of marijuana is a felony as well as the MDMA. So he has currently 4 open cases, one of which he bonded out in December 2023 on an FTA. So he is a risk of reoffense. He is a risk of not returning to court. He is a risk to our victim, and he is a risk to the community, given he has a current open armed robbery and aggravated assault case. For that reason, we're asking for a $7,500 surety bond, $2,500 on the criminal trespass, and $5,000 on the disorderly conduct. No further contact with Ashanti Barber or Tracy Thompson, and stay away from 2040 Stanton Road, apartment F12, East Point. No alcohol, drugs, or weapons. There was, and I will say, an MH evaluation on the 23 SC 19039 case, 393 case. And so we are also asking for an MHET. That's all for the state. And we would like to sound for Ashanti Barber in case she is here today.
Ashanti Barber. Ashanti Barber. I don't think she is. Go ahead, PB Armstrong.
Thank you, Judge. We're going to ask for a signature bond in this matter through the jail, given the other matters that Mr. Dudley has going on before the court. I do want to point out that the FTA, I'm concerned, and I don't want to make any misrepresentations to the court, but just in looking at this, at the Fulton County system, it appears that the apartment number that is in the system is not the one that my client just communicated to me. I can send that information to Ms. Bridgewater, of course, so we can get that correct. But again, I'm concerned that maybe the FDA happened because maybe there was a lack of notice for any other court dates. I can't confirm. I just want to make that aware to the court. If your honor had any concerns about appearing, my client advises that he does mentoring with his mother, who is very close with, talking to young men about how to not end up in situations like he has found himself in. Again, we're renewing our request for a signature bond through the jail. Thank you.
All right, I'm going to give a $5,000 signature bond. And you told me he was working?
Yes, he does some mentoring programs. It's my understanding that he mentors other young men with his mother. I'm not sure if it's necessarily something that they get paid to do, but he's also a tattoo artist. So he is self-employed.
And Your Honor, I just want to reiterate, this is his 4th open case in Fulton County.
Yeah, I was looking. I was counting 1, 2.
And I can give you the case numbers again if Your Honor needs them.
I have 2. Give me the other 2. I've got the 23 and the 24.
Are those the CRs or the SCs?
The CRs.
Okay, so there's a 23 SC 190393 armed robbery aggravated assault, which he's currently out on a $75,000 surety bond, and a 24 PI 004253 possession of marijuana felony and possession of MDMA, which he was arrested on from an incident on June 12th. He was arrested when he was arrested on this case, and that should have gone to felony first appearance today, but I'm not sure if it got a bond or what the bond amount was.
He was on the felony first appearance today.
I told you I was
Just instead of
12-5.
12-5.
Yeah, oh, it was
Thank
12-5.
Yeah.
My apologies,
12-5 split bond.
Mr. Howard.
Okay. All right, let me change that. I'm sorry, Mr. Howard, you get your white out again. A 20, make that a 5,000 surety. That'll be 3,000 on the disorderly, 2,000 on the criminal trespass. So 5,000 surety. No drugs, alcohol, weapons, or guns while on bond, and a stay away from that 2040 Stanton Road. And there was did we have a victim? I guess Ashanti Barber.
Yes, and we're asking for no further contact with both Ashanti Barber and Miss Tracy Thompson, who is her mother, who also, according to the police report, both of them reside at the same address.
All right, and no further contact with the 2 victims, Ashanti Barber and Tracy Thompson. And I guess that's it.
Position 21. 21.
21. Okay. This is 24 CR 0038225E. Eric Smith, charge of 1 count of criminal trespass.
11. Last arrest was this year for trespass. He's
Okay.
on probation for that as of April. Got another open case for obstruction, felony, and trespass. 23 CP 222117.
Okay.
On probation for PI and trespass. 24 CR 004860. On probation again for certain acts on bus rail trespass. 23 CR 005610E. Another probation for trespass. 24 CR 001437E. 2022 violation of family violence order conviction. 2023 battery NOLO. 2022 terrorist threats conviction.
All right, state.
Yes, Your Honor. The defendant is accused of criminally trespassing upon the Lindbergh MARTA station. The defendant had previously received a permanent ban from the MARTA on September 18th, 2023. The state recommending a signature bond through pretrial. Stay away from all martyr locations. No drugs, weapons, or alcohol while out on bond.
All right. PD Wright.
Your Honor, we would ask that you accept that recommendation from the state.
And that was how much on the state's recommendation?
It was a signature bond at whatever amount the court deems appropriate.
All right. $2,500 signature bond through the jail. Stay away continually from all MARTA. Say that again and again and again. No drugs, alcohol, weapons, or guns while on bond. And that should do it.
Thank you, Your Honor.
Okay.
Number 23, Wilson.
Okay. This is 24 CR 003828J, Benny Wilson, charged of 1 count of criminal trespass. Pretrial.
38. Open trespass 23 CR 002735J. 2018 disorderly conduct conviction. 2014 probation and 2012 FTA.
State.
Yes, Your Honor. The defendant is accused of remaining on the property of the Chevron gas station located at 180 Ponce de Leon Avenue, Northeast Atlanta. The defendant had previously received a criminal trespass warning on May 25th, 2024. The state is recommending a signature bond through pretrial services. Stay away from that Chevron and no drugs, weapons, or alcohol while out on bond.
All right. PD Wright.
Your Honor, we'd ask that you accept that recommendation.
Okay. I will give them a $2,000 signature bond through pretrial. Will you take him pretrial?
I mean, it had to be per judge. You already got open case.
All right, let me do it through the jail. $2,000 signature bond through the jail. And no drugs, alcohol, weapons, or guns while on bond. Stay away from the Chevron 180 Ponce de Leon. No, and I think I already said no drugs, alcohol, weapons, or guns while on bond. Stay away from the Chevron, Mr. Wilson. All right. That's it.
Thank you, Your Honor.
Hmm.
Ma'am, may I talk to the judge about getting past program Sunday? I can get off the street.
Need to talk to your attorney.
Do you remember I gave you our address, Mr. Wilson?
No, you didn't give me nothing.
When we were on
Might have been the other Wilson. You haven't given me no paperwork.
Your Honor, if I can, I'm just gonna, if the jail could call me so that I could speak to him, I can give him more information.
Okay.
Go to the phone over there. Next is number 1.
Okay. All right, this is 24 CR 003807D, Brandon Black, charged with 1 count of reckless conduct, 2 counts of disorderly conduct, and 1 count of criminal trespass and damage to property. Pretrial.
I got first arrest.
Okay. State.
Yes, Your Honor. This incident happened June 13th of 2024 at 68 Springside Drive Southeast. Officers responded to a firearm call. They observed the defendant striking a mailbox at that address and shouting. They couldn't understand what he was shouting. He was clearly intoxicated. The defendant claimed he was upset with his neighbor, Mike McMichael, for not being involved in his son's life. He denied to the officers that he had a gun or damaged the mailbox, even though the officers, when they drove up, saw him damaging the mailbox. They did speak to Mike McMichael, who stated he saw the defendant, his neighbor, outside. The defendant was yelling and produced what appeared to be a black Glock, which he fired twice into the ground. The defendant then began banging on his door, calling Mr. McMichael a bitch multiple times. Officers found a live 22 caliber round and then located an airsoft Glock gun in the front yard of the residence adjacent to the defendant's residence. Although this is the first cycle, we are concerned about this behavior. It is highly unusual for something like this to happen and definitely put Mr. McMichael in fear. We have had a chance to talk to Mr. McMichael. He stated the defendant, he believes, has a history of alcohol and drug use and MH. He stated when he first met him, he tried to take him under his wing because the son didn't have a father figure. He stated, sorry, he doesn't, the defendant didn't have a father figure. He stated the defendant and his son are close in age, so he felt that they would become friends, but it turned out to be a bad decision. He stated that the defendant and his son began to do drugs together and they almost died due to an overdose inside of his house. He did confirm the events in the warrant and stated he wants no contact, stay away order. He's also asking for ADET and MHET. And no firearms. Currently, there's a $6,000 surety bond set on this case. We are asking that it be increased to $10,000, $2,500 per count. We're also asking for a stay away from 68 Springside Drive Southeast, no further contact whatsoever with Mike McMichael, as well as no alcohol, drugs, or weapons in an ADET. We would like to sound for Mr. McMichael at this time. He did state he would not appear on Zoom, but we just want to sound for him out of an abundance of caution.
All right, is Mr. McMichael on the line? Nope. All right, PD Armstrong.
Judge, Mr. Black takes care of 3 aging people. His grandmother's going blind and she has dementia. His mother was in an accident and she receives disability. And then his uncle suffers from severe schizophrenia. There is no one at the home to take care of them. My client was trying to tell Mr. McMichael to leave him alone. He has been wanting Mr. McMichael to leave him alone for a very long time. And so he welcomes the opportunity to have a stay away from him. He needs to go home. He needs to be able to continue taking care of his family. Because again, there is nobody that is physically able to do so. He does have a CDL, but he cannot work right now because he has availed himself to be the primary, both physical and to care for his family entirely. He doesn't go out. He doesn't leave the house. He has more on his plate than any man of 36 years of age should have. And this is his first arrest. So we are asking, Your Honor, to grant a SOB through the jail in this case. Moreover, this alleged Glock, it appears in the warrant that the alleged victim in this matter conceded that he or had knowledge that my client had a BB gun. There are BB guns that can look like weapons, like Glocks. This was not a Glock. This was not a gun. There's no evidence to support that. So again, I renew my request for an SOB jail in this matter.
I too am concerned about the allegations and the gun.
There was actually an airsoft weapon collected.
There was, as well as a 22 caliber shell casing, or a 22 caliber live round, excuse me.
Correct, and I apologize for talking over this. This is just one of those cases. This shell casing was not spent, and that actually contradicts what the alleged victim said in this case, that there was shooting of a shell casing. Again, there is no firearm found, only a BB gun.
Let me order $3,500. Well, I'm sorry, there's already a 6,000. Do we know the breakdown on the 6?
Yes, Your Honor. The breakdown on the 6,000 that was set by the magistrate judge is 2,500 on the reckless and disorderly, 1,000 on the criminal trespass.
Okay.
And we did add a second disorderly, so that's why the breakdown's a little different.
A little different. Okay. Let me stick with the 6,000 surety on it. I know it's his first arrest, but they're pretty serious charges. And that's not too high of a bond. Does he work and everything?
Judge, again, he cannot work because he has to take care of his family full time. He has a CDL that he cannot use it to be employed because he has to stay home to take care of 3 aging people who he's terrified of what's happening at the home right now without him there. He gets their groceries, he takes them to their doctor's appointments, he schedules their doctor's appointments, he gives them their medication. And I'm sorry if I'm getting heated. I have issues with this in my life personally. I know we're not supposed to insert our personal lives in these matters, but his family might suffer severe consequences if he's not there to take care of them. And I'm very, very concerned about that. So I understand the state's concern, but my concern, A, is my client's liberty, and B, also the fact that making sure that he can take care of his family. And the last thing I'm going to say, hopefully, is that he lives on about $300 a week. So a 6,000 surety is prohibitive. He cannot post that. And there's not an able-bodied person in his life to help him post that, to facilitate the posting of that.
And Your Honor, the state is sympathetic to the situation. However, I can't be more sympathetic for him than I can be for our victim. And the reality is, I'm not sure who was looking after all of these people who were in such dire need when he was outside of this man's home at 8 p.m. drunk, destroying property. You know, I'm not sure who was taking care of his family at that point, but it certainly wasn't him.
Respectfully, this neighbor is not an expert in intoxication, and the defense takes offense to
it was the police who stated he was intoxicated, not the witness.
We don't know if they're certified to recognize intoxication, Judge. I have nothing else to say.
All right, I'll leave the bond at the 6,000 surety. No drugs, alcohol, weapons, or guns while on bond, and obviously a stay away from the 68 Springside Drive. No further contact with Mike McMichael.
Your Honor, will you break that bond down, please?
I think it's 1,500 on the first reckless, 2,500 on the disorderly, and trying to remember what Deputy Falk. What did you have? Correct me.
It was 2,500 on the reckless and the disorderly, 1,000 on the criminal trespass. So it is going to have to be kind of reallocated a little differently unless Your Honor wants to insert
mathing up.
Or unless Your Honor wants to insert a $1,000 signature bond on the other disorderly and make it a $7,500 split bond, or a $7,000 split bond. Excuse me.
We can do a 7,000 split. Let's do that.
Okay. Now, with that being said, let's start over again.
Right. That'd be 2,500 on the reckless, 2,500 on the disorderly, and then
I had 1,000 on the
1,000 on the second disorderly, and then a 1,000 signature on the criminal trespass.
And that signature is through the jail?
Yeah.
I thought it was vice versa. I thought it was $1,000 on the trespass for damage of property, which is already posted on the screen, and $1,000 SOB on the second conduct.
Yeah, the breakdown that I have for the 6,000 is
Let's listen to Deputy Falk. She's got it
2,500 on the reckless, 2,500 on the disorderly conduct, 1,000 on the criminal trespass, and then I would recommend a 1,000 signature on the other disorderly conduct, which would then match what's on the jail screen.
There you go. There you have it. Sorry about that. I didn't mean to be too confusing.
No problem.
Well, you've done a good job today. So are we doing a 6,000 or a 7,000?
6,000 surety and 1,000 SOB jail.
So a total of a $7,000 split.
Correct. See, you got it. I didn't do too bad.
Don't speak too soon, Judge. Okay, gotcha.
Okay.
Number 3.
3 is 24 CR 003808A. Robert Michael Coleman, 1 count of criminal trespass. Pretrial.
Uh, 14 total. Last was 2023 trespass. That's open 23 CR 005-071A. You got 2 more trespasses from 2023, 2019 trespass conviction. Another 2019 trespass conviction, 2018 disorderly conduct. I think he's homeless.
Okay. State.
Your Honor, this happened June 11th, 2024 at 3072 Washington Road, which is the Polaris at East Point. A criminal trespass warning was issued previously on June 7th by the property manager, Mr. King, after the defendant was found entering a vacant apartments multiple times. The defendant was then found on June 11th in a vacant unit. He does currently have a FTA on 23 CR 005071A, where he's being held on a $1,500 surety bond. On this case, he has a $2,500 surety bond. We are asking that it be reduced to an SOB through the jail. Stay away from the Polaris Apartments at East Point, which is at 3072 Washington Road, and no alcohol, drugs, or weapons. I will say neither of his previous 23 CR cases, including the one he's currently in jail on an FTA, involved the same location.
Oh, different locations. Okay.
Yes, it is.
All right, PD Armstrong.
Thank you, Judge. Yes, he is residentially challenged, so we would have no objection to a signature bond in this matter.
All right. So we'll do a $2,500 SOB jail and no drugs, alcohol, weapons, or guns while on bond. Please, please stay away from 3072 Washington Road to Polaris at East Point. And I hope, Mr. Coleman, you get some assistance with housing. Is the PD's office able to get him an interview with the social worker to find out what we can do to help him with you all can do to help him with homelessness?
Yes, Judge. And this case would actually go to Miss Wright in her courtroom, and we've also spoken about the FTA getting that lifted on Monday. And then I don't want to speak for her, but I'm sure she'd be happy to facilitate a connection with the PAD program.
Okay.
Well, and our social workers. So
right. I don't know if you should say anything, Mr. Coleman. Your attorney will probably tell you not to, because you have a signature bond.
Excuse me.
My apologies for that, Your Honor. Mr. Coleman, please don't say anything to the court. We can talk about anything you want to talk about later.
Okay.
This may have, because I have a job. I just got a job, but I just want to ask something, ask a question. That's it.
I'm happy to call him after the calendar, Judge, if that's.
He's going to call you after the calendar, okay? You have a signature bond. I don't think he understands.
No.
Possibly.
No.
Okay, she'll explain it to you shortly after we finish with the calendar, okay? Okay.
Well, Mr. Hope.
This is 24 CR 003816G Bersharn Holt, charge of 1 count of criminal trespass. Pre-trial.
I think I counted about 75.
75?
Yes.
Okay.
You want me to keep going?
No. What's the most recent one?
I got a 2023 out of Meriwether County, obstruction, trespass, conviction.
Okay.
Also
All
on
right.
probation, criminal damage to property out of Meriwether County.
Okay. All right. Thank you. State.
Yes, Your Honor. The defendant is accused of trespassing upon the BP gas station located at 1450 Donnelly Avenue Southwest in Atlanta after being asked to leave the property multiple times. The defendant had previously received a criminal trespass from the location. The state's recommendation is a signature bond through the jail. Stay away from that BP gas station. No drugs, weapons, or alcohol while out on bond.
All right. You be right.
Yes, Your Honor. Thank you. We would ask that you accept that recommendation from the state.
All right. I will order $2,000 signature bond through the jail. And please, Mr. Holt, stay away from the BP on Donna Lee Hollowell. No drugs, alcohol, weapons, or guns while on bond, okay? All right.
You said 1,000 or 2?
2.
Who do we have next?
One person, 16. We have one.
Position 16, waivers present.
Okay. And then we have an add-on. All right, 24 CR 003819C, Kenneth Pack, 1 count of criminal trespass, pretrial.
What we got here? 30. Got an open criminal damage to property in Superior Court, 23 CP 220146. Open case out of Clayton County for shoplifting, trespass. Open case out of the cab for trespass. We had 2 trespasses. I think he's homeless too. He got a lot of trespass from 2023.
Okay. State.
Yes, Your Honor. The defendant is accused of trespassing upon the College Park MARTA station. The defendant had previously received a permanent suspension from MARTA on January 26, 2023. The state is recommending a signature bond through stay away from all MARTA locations, no drugs, weapons, or while out on bond.
All right. PD Wright.
Yes, Your Honor. We'd ask that you accept this recommendation from the state.
Okay, that was SOB pretrial. 1,500 SOB pretrial.
Now he's homeless, Judge.
Oh, so he can't report. Let me do 2,500 SOB jail. And where'd he go? He's gone.
He was a waiver, I think.
Oh, it was a waiver. Duh.
I think so.
Okay.
I don't show anything. I
I thought we had the one person. Who's that in the back? That's not him?
Yeah, I still have positions 7 and 10 in
I was
the
gonna say the add-on.
we
Right,
haven't
in the add-on.
addressed.
Who's that in the back?
That's the person that want to talk to you.
Oh, that's Mr. Williams or somebody? Wilson?
Oh.
Who is
I've
that?
already spoken to Mr.
Oh,
Wilson.
man.
Mr. Cole?
I'm sorry, Judge, to speak over you. Just a reminder, I believe he doesn't understand that he has a signature bond. I think that was that case.
Okay. Oh, so was 16 was a waiver?
Yes, Pat.
Mr.
I
Pat?
have not received any waivers today.
And I did not file a waiver. I spoke to Mr. Pack today. I'm not sure why he's not present.
Oh. Where's Mr. Pack?
It's gonna be reset to Monday.
Is there a basis for the reset to Monday?
He did not want to stay for court.
Oh, he was there but did not want to stay.
Correct.
Hadn't had that one before.
Can we still set his bond? I mean, like I said, I spoke to him. I'm not sure what could have upset him or what, but I didn't have any inkling.
Has he waived his presence?
I'm sorry?
I said, has he waived his presence?
No, she spoke to him.
I spoke to him and nothing came up.
I think we can proceed with bond hearing without the defendant waiving his presence, and he hasn't. He left. I can't just say, okay, well, let's pretend like he's waived.
Can you all go
ahead
and ask him if he's going to waive his presence to get a bond? And then PD Wright can file that. Deputies, are you all able to go speak with him?
Yes.
Okay.
And I still have positions 7, 11,
that
and 10.
add-on. Let's see.
And
Oh,
I have 4 positions, 7, 10, 11, and the add-on.
And are you talking about position 12 as well?
Well,
No, I thought we just did 12.
Sorry. Then PAC would be the other one.
PAC would
Yeah,
be the
PAC was position number 16.
Right. So I have
Okay.
7, 10, 11, 16, and an add-on that have not been addressed.
Right.
All right, position 10 gonna be a medical reset.
What number?
Position 10, Harvey.
Okay, thank you.
Thank you.
Come on, man.
okay.
No, it was a big.
And
11.
still waiting on, position 7 and 11.
Position 7, Green, she will not produce from ACDC, so she's gonna be reset to Monday.
Judge, the defense has a motion in that matter.
And 7. 2 days, 6:15. What are we doing on 7, Whitney Green?
They need to produce her because this would be a Riverside issue and the state does not consent to a signature bond on this. So I don't know how they're going to find her, but they need to go find her because that's we need to have her case addressed.
They say she's at ACDC. Do you have a number to contact over there or anybody to?
They used to call, at least call on the phone. Huh?
I gave Ms. Armstrong the number to call over to ACDC earlier.
Yes, and I very much appreciate that. And unfortunately, I wasn't able to establish contact. I was on hold for a very long time and unfortunately had to report to the court. So I did try that number, but we were not successful. And at this point, we would be moving under Riverside.
So you weren't able to speak to the client?
That's correct, because I'm nothing. I'm not trying to shift any blame or anything. It's just I found out that she was at ACDC, but then I found out there was not I was, and please tell me if I'm wrong, a court officer at ACDC. So I did use the number that I was provided, but I couldn't get through. I did let my supervisor know, and at this point, it's our office's position that this would be a Riverside issue, and we just asked for a signature bond, and it shouldn't be that she stays in custody longer than she should, maybe because there wasn't sufficient there wasn't an officer to facilitate court. So,
and Your Honor, the allegations in this case is of a sexual assault of a 16-year-old boy. The mother is here.
Judge, I would ask that my client be present for anything.
And we agree. She needs to be present. And so the state does not waive her presence. The state does not say, let's do a Riverside on Monday. The state is saying we are willing to sit here until they bring Whitney Green.
And who's the mother?
The mother here is Miss Chele, April Chele.
Okay.
And she is present, Your Honor, and she has made her wishes very clear to the state, and we are willing to go forward.
Deputies, can you all call down there too? Maybe they'll answer you all.
I'll call to give me about 10 minutes.
Okay, thank you.
Position 11, bond post to hearing.
Oh, 11, okay.
And the add-on reset behavior.
Reset for what?
Behavior.
Behavior.
Add-on behavior. And what did we say? What's 11? Are we resetting 11?
Oh, no, 11, he said posted bond.
Okay.
He's posted bond. For some reason, I'm having a hard time hearing.
Yes.
So 11 was released.
Right.
Okay.
And 1 is reset behavior. 1 add-on, I'm sorry.
Yes, okay.
And I am confirming that Mr. Henry was released on a $6,000 bond.
Is that what you all have, Deputy? 6,000?
I am seeing it on the jail screen, Your Honor.
Gotcha.
And was anyone able to make contact from the public defender's office with the add-on?
Well, maybe not if it's behavior.
No, they're saying they reset
Did you all
because of
interview
behavior.
him? Yeah, did you all interview him, Miss Armstrong?
I'll defer it to Miss Wright.
Miss Wright, did you get to interview the add-on?
What was the last name for the add-on, Your Honor?
Williams.
Williams. Another Williams?
No,
Calvin Williams.
no. I did not.
Okay.
If we make contact with him, I'm happy to do so.
Mm-hmm.
Judge, I believe the jail just tried to call me. I did not want to accept the call prior to letting Your Honor know. If I
go ahead.
Thank you.
Williams probably got mad about that no bond from felony.
Hmm.
And number 10 got capital offense, so he ain't going nowhere, no way.
Mm-hmm.
Do we have time?
I'm sorry.
A little bit.
Mr. Williams, he was agitated about that no bond, and one of the officers took him back, so it was about to get out of hand.
I figured that.
Mm-hmm.
Okay, what?
Can we go over the calendar?
Yeah, we can do that.
Okay. You all ready? Okay. Once again, the reset date for the SAP calendar is going to be June the 27th. Position number 1 is going to the SAP calendar with a total $7,000 split bond. Position 2 is reset further notice with a total $7,500 SOB through pretrial. 3 is reset further notice with a $2,500 SOB through the jail. 4, reset further notice with a $3,000 SOB through the jail. 5 is going to the SAP calendar with a total $5,000 good bond. 6, reset further notice with a total $5,000 SOB through pretrial. Position 7, we're holding on. Position 8 is reset further notice with a total $5,000 SOB through pretrial with the co-signer of Brittany Hammonds. Position 9 is reset further notice with a $3,500 SOB through the jail. 10 is a medical reset till Monday. 11 was released, therefore it'll be reset further notice. 12 is reset further notice with a $2,000 SOB through the jail. 13 is going to the SAP calendar with a total $2,500 good bond. 14 is reset further notice with a $3,500 SOB through the jail. 15 is reset further notice with a $2,500 SOB through the jail. 16, reset further notice with a $2,500 SOB through the jail. 17 is going to the SAP calendar with a $1,500 good bond. 18 is reset further notice with a total $3,000 SOB through the jail. 19, reset further notice with a $2,500 SOB through pretrial. 20, reset further notice with a $2,500 SOB through the jail. 21, reset further notice with a $2,500 SOB through the jail. 22, reset further notice with a total $5,000 SOB through the jail. 23, reset further notice with a $2,000 SOB through the jail. And the add-on is reset till Monday for a behavior reset. Are there any questions, comments, or otherwise?
ACDC will be logging on in about 10 minutes. Stand by.
Thank you.
Thank you.
So was that Mr. Pack I saw just walk by?
Looks like.
Judge, I will need a brief breakout room with Miss Green once she joins the court, as I do need to speak with her.
Okay.
And I'm sorry, I missed that. Did we say whether we made contact with Mr. Pack?
Well, we saw someone walk by.
I thought that was him. But now
Courtroom
it's
two.
my understanding that he did not file a waiver. And do we need to, are they still going to get him?
I would love to have him in front of the judge if possible.
Courtroom two, can you unmute and let us know who that was who just walked by?
Can't hear. Oh.
That was Coben that just walked by.
Oh, where's Mr.
Pat.
Pat?
Say he's not interested in coming back.
He said he's not interested in coming back.
No, ma'am. He said they go ahead and set the bond.
Well, he has to have a waiver and his attorney needs to know that.
He'll be reset then.
We can't, isn't he Riverside Deputy Falk?
Let me double check, but I mean, it would be a different situation if the defendant is saying he is not participating versus the jail saying they cannot bring someone.
Deputy, is he able
There
to get
is
on
a
the
difference according to Riverside.
Is that him?
Who is that?
That's Bogo, the officer.
He gotta identify himself.
He got a beard. He got a beard now.
Oh, that's what it is. Okay.
I'm so sorry.
I know.
Should have
Look,
put
and
him
he's
in that chair.
really rolling his eyes at us and the jacket zipped up and
I'm telling you. Oh, you better say something.
really
It's 99 degrees outside. How cold
it is
in the jail?
Is it
have
cold
to
at
wear
the
a
jail?
sweatshirt. It's got to be cold in there.
You pleading the fifth.
And I mean, I'm not sure if this would be considered a behavior reset since he's refusing to come out, or I know that when this has happened before, we've tried to send somebody with a cell phone to see if they'll talk that way, but I don't know if you guys have a cell phone available today that you can send up there.
We don't.
And he doesn't want to talk to me either, Deputy?
When he spoke on the phone, he said when they first called, he said he wanted to wave, then the phone disconnected and they called back.
He's hot and frustrated.
So he did want to, officer, you heard him say he did want to waive?
I did, ma'am.
Okay, Your Honor, if it would be all right, I'm happy to file a waiver.
You would
I will
need
do
to.
that. I will do that immediately.
Okay.
So with that being said, this order is still good then?
It looks like it is. It's 2,500 SOB jail.
That is correct.
Yeah.
Okay, so I'm gonna submit it to you for your signature.
All right. He was to stay away from
All Marta property.
All Marta, because he's permanently suspended.
Okay.
Okay.
That was a good fix. Thank you.
And it looks like ACDC has just come online.
Okay.
Thank you, Deputy Bogle.
Ain't no problem.
Thank you.
You still need me to put you in a breakout room with her, Mr.
Oh, that's right. They need to go talk first. Yes.
I just wanted to alert everybody that they just came up.
Okay. Do you all know who Kizzy Anderson is?
Is that the mother?
No, Miss Chele is the mother.
Who's Kizzy Anderson?
That might be somebody from jail records.
Oh.
I think. Let me call over there. Hold on.
Okay. That's the only outside kind of, or someone
She
not
works at the
identified.
jail in the records room.
She does. Okay.
She just put something in the chat, so.
Oh,
give
I
us a
see it.
heads up.
Okay, just checking. Oh, I didn't see your chat, Shelley.
Your Honor, you want me to go ahead and send what paperwork I have?
Go ahead.
Okay, it's not in numerical order, but nonetheless, it's good to go. I can put it in order after I get it back.
Okay. Yeah,
And
Deputy.
Your Honor, I could definitely have PD Haddad there for that conversation as well. We just needed there's some confusion about how
Yes.
that how it is structured.
Oh,
And we
yeah, we
wanted to
need
get
to
some
talk.
clarity before July 1st.
Somebody may need to bring food and drink so we can have that talk.
Yeah, I also spoke to Judge McBurney, and apparently that same confusion is on the Superior Court side as well. There's a subsection that is contradicted by a different subsection. And so we wanted to kind of get together before July 1st and try to figure out which direction we would be going in.
Right. You guys are off next Wednesday for the holiday, right?
That is correct, but I'm available on Monday, Tuesday, and Thursday, and I can check with PD Haddad and see his availability as well as Mr. Emden and Mr. Jordan, because they're going to want to be there as well.
Okay.
Don't forget you guys are still live.
Say what?
Pardon?
Forget y'all still live on YouTube.
Oh no, that's fine. I mean, there's nothing, not hiding the ball on this one. we just want there. We need some clarity on a legal issue that's going to come up July 1st.
So I guess do each of us, because you got 4 more of us to get in. It's going to be so many people to try to get together.
If Your Honor is okay with that, and if the other judicial officers are okay with that.
Well, Nataki, he sent us something saying that we needed to meet.
Okay.
So I'll respond back to him, which I hadn't. I saw it late Friday, right?
That would actually be great. And if you want to just discuss it with the clerk's office and then he can come back to us, that's fine too. I don't mind
think
either way. I just
schedules, and we're all in private practice too. So he's probably thinking, oh boy, that's a hairball trying to get us all together.
I was just trying to make sure that Your Honor was aware that that is something that we have all been discussing and wanted some more guidance.
Oh yeah, we do. So I'll do that, and I'll call Judge Williams and make her aware of that email if she hasn't seen it, so that we can kind of give him our schedule and see if he can get us all together, either with you all or us, and then bring it back to you all.
Okay, thank you, Your Honor.
Appreciate it. Because before we know it, it's going to be July 1, right?
That is true.
June is escaping.
Does Miss Bridgewater want to know, did you receive the paperwork yet?
Oh, let's see. Oh, I'm sorry, I forgot that quick to look. Just got it.
Excuse me, Your Honor. Who should I email that waivers to?
Miss Bridgewater.
Thank you.
Holly Bridgewater.
Hi, Miss Lewis.
Hello, Judge.
I haven't been with you in a little while.
That's correct.
Hey, can someone let ACDC in?
Oh, okay.
Well, just like it.
Ms. Wright, I received your email. However, you didn't send a copy of the attachment.
I know. I'm such a wrong
It's
button.
okay.
1 second.
No problem.
It's so embarrassing every time.
No,
I'm so
no, no
sorry.
need to be embarrassed.
Well, I just want to first of all thank everyone for their patience, and of course, to the jail for facilitating being able to speak with Ms. Green. I do greatly appreciate it. And if we could handle this matter in the way that was proposed for another defendant on this calendar with the same charge, Your Honor, in terms of.
So you're asking for the breakout?
Yes.
Or to stop the recording since nobody else is on here?
It would be